Since we're here to talk about the arbitration statute, I'd like to talk about two experiences, just to give as an example, of cases that I've handled involving the arbitration statute. The claimants were a husband and wife who went to a local urgent care clinic. Unbeknownst to them at the time, the husband presented with classic symptoms of a medical condition known as Cauda-Equina syndrome. His condition was misdiagnosed, and by the time he was able to obtain proper surgical care in the Philippines, he suffered a permanent debilitating neurological condition. The arbitration process took nearly 5 years to complete. The claimant's cost of arbitration alone amounted to $47,186. In addition to the $47,000 in arbitration costs, the claimants incurred other litigation expenses in the amount of over $66,000. In my years of experience, vast majority of potential claimants who come to me for a consultation do not have the resources to afford to go through arbitration. In nearly all potential medical malpractice claims on which I am consulted, once the prospective expenses are described, the claimants choose not to pursue their claim due to the inability to afford those costs. And how many of us can afford $113,000 to pursue a medical malpractice claim? Victims of medical malpractice are oftentimes made uniquely vulnerable by the negligent treatment that they have suffered. They are often subjected to debilitating consequences of the malpractice. They are out of work, financially unstable, and most likely physically compromised. Faced with a 1-year statute of limitations, the excessive costs of arbitration and litigation, plus the difficulty of finding an attorney who's willing to handle their case, potential claimants find more often than not that their claims will just go unredressed. They will not be made whole. The Mandatory Arbitration Act exacerbates their circumstances inordinately and, in essence, tends to erode rather than promote corrective justice.